Hey, yo, folks, and welcome to YNW Melly update. Yes, we have the search warrant, the document, against Raven Liberty and her iCloud account. There are some really interesting things they asked for and got approved by a judge. Really interesting for me. Just the fact that they tried to hide this from the defense for over a year. And it is supposed witness tampering. And when you find out the supposed tampering and against what witness, you are going to lose it. You are going to lose it. I know roughly what's in it because I've seen other people talk about it, but if you haven't seen it yet, this is unheard of, in my opinion. Unfreaking heard of. Let me just... All right, let's see here. What can we do? We can share screen. We can go over here. And I say it's 10 pages. It's 10 pages, but it contains a lot of information. Let's see here. Where should I position myself? Here? Or at the side? I need to get... Oh, hold on. Can't have that. Can I have that up there? Yeah, I can have that up there. Okay. What we don't have is the affidavits that the investigators, the cops, gave to whatever judge this is in order to get this search warrant approved. We don't have that. But I assume that Mellys defense will go gunning for it. And after we are done, after we have read through this one, let's see here. Oh, Yeah, I have the state's wish regarding what in Raven Liberty's iCloud they found. They really, really don't want anybody to know. They really, really don't want anybody to know. And we knew that from the get-go when this was revealed. What was it? Just before Christmas. Oh, the prosecution weren't happy. The judge wasn't happy. Defense was furious that this was allowed to go on. In my opinion, this is clear misconduct from the prosecution. Clear. But let's read through it. From the Broward Sheriff's Office, directing the activities of a criminal gang. This investigation does not involve a prohibited violation as defined in Cal Penal Code but rather concerns tampering with witnesses and directing the activities of a criminal gang. Yes, what they accuse Raven Liberty of is more or less helping the YNW gang with witness tampering. Fun size as was it bad for the defense side? I don't think so. I really don't think so. It's Apple's cloud service. Grounds for issuance. Pursuant to this, property has been used as means to commit any crime and/or property constitutes evidence relevant to proving that a felony has been committed. Pursuant to Florida statutes these, as well as the United States Code this and California statute that, a judge of the Circuit Court of Florida has jurisdiction to issue a search warrant for the account to be searched. An out-of-state corporation that provides electronic communication services or remote computing services to the public, which possesses records that would reveal the identity of the customers using those services, data stored by or on behalf of the customers usage of those services, or their recipients, or destinations of communications sent to or from those customers, and that such warrant shall be executed by civilian personnel employed at account to be searched and at the out-of-state corporation that provides electronic communication services or remote computing services to the public. Translation. We want to go through Raven Liberty's phone, specifically iCloud, the cloud service. Property sought. The affiant is authorized to seize the below described evidence pursuant to Florida statute, blah, 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 United States Code, blah, 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 and California statute, blah, 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 which compel out-of-state electronic communication service or remote computing service that provides such services to the public to provide information requested pursuant to search warrants, court orders, or subpoenas issued in the state of Florida. However, because the out-of-state electronic communication service or remote computing service provider has no reasonable means to distinguish evidence of crimes from any other records contained within the sought-after account, the affiant is authorized to compel the service provider to seize a copy of all records pertaining to the account and provide the entirety of the records to your affiant. Now, what does that mean? That means that everything on Raven Liberty's storage units, everything, including but not limited to attorney-client privileged information, was handed over to the investigators. Everything. And they've had that for over a year. Over a year. Give me a hands up, everybody who says, I trust them. They wouldn't go look for those things. Once the affiant has obtained those records, the affiant and or other agents authorized to execute this warrant or to assist therein shall conduct an actual search of the items obtained from the out-of-state electronic communication service or remote computing service provider in order to sort the evidence of the crimes articulated below and specifically sought herein, which may be intermingled with innocent or innocuous documents or records. As such, there are two sections below. The first, which articulates what the out-of-state electronic communication service or remote computing service provider is obligated to produce to the affiant, Detective Christina, I seem to see. The second section articulates more specifically the particular property sought, which shall be executed by the affiant and or the affiant's colleagues after the affiant receives the item sought from the out-of-state service provider. And do what DWAT says. Hit that thumbs up. Okay, folks? Hit that thumbs up. God damn, I deserve it. Law enforcement is hereby authorized to search the following. Property to be provided by Apple Inc. Device registration information, including but not limited to customer information, names, addresses, email addresses, and telephone numbers, date of registration, purchase date, and device type, including any associated email or ESN. Her entire contact list, including but not limited to other clients or prospective clients. Apple ID and related accounts details, including email addresses, account status, age, associated device information, serial number, and browser type. Yeah, what's in the phone? Apple-based and third-party applications downloaded. If they used an encryption app, now it's in the hands of the state. Apple Media Services, purchase, download, transactions, and connections. Update, re-download connections, IP address information, Apple customer information, and connection logs with IP addresses. Apple Media Service purchase, download, transactional records, and records of the specific content purchased or downloaded. Bank data, if she used her phone to purchase things and other stuff. iOS device activation data, when did she use the phone and when didn't she? Connection logs, when did she call people? Apple ID and I forgot logs, if she deleted stuff. FaceTime logs, did she FaceTime anybody and when? Location information, where was she? Health data and fitness data. Did they take walks? Did she... Yeah, whatever's in there. Device analytics. Purchase history. iCloud data, including but not limited to subscriber information, including but not limited to basic subscriber information such as names, physical addresses, email addresses, telephone numbers, and information regarding iCloud feature connections. Again, if she has other clients, they now know who they are. They now know when she called them, where she was when she called them. And this might be people who have her on speed dial for different reasons. All of them. The information are now known by the state. B. Mail logs, including but not limited to records of incoming and outgoing communications such as time, dates, sender email addresses, and recipient email addresses. Every communication she ever had via her Apple iCloud data. C. The contents and attachments of all electronic mail, including embedded images, iMessages, instant message logs, or other communications contained in the above listed iCloud account and any related accounts concerning the same subscriber, including all header information, originating IP logs, and attachments for each message contained in the account, including but not limited to the content and header information of email messages. All electronic communications should include drafted, sent, received, opened or unopened, read or unread, and or forwarded between February 13th, 2019 to present. That date is important because I believe that Raven Liberty wasn't obtained by Melly until like a month later or something. So they want information prior to her even being his attorney. And everything she's ever done with an Apple device, clients, other attorneys, everything is and has been in the hands of the state for over a year. Everything. Nicola Cox, why did they do this? What did she do? They claim that she committed witness tampering, and we will come to that. We will come to that. When I tell you, you're not going. Yeah, you're not. Yeah, you're going to lose it. Safari browsing history. Which pages were she on? What did she look at when she was on it? Everything. Photo stream data to include videos and other medias. If she recorded meetings with clients. iCloud photo library to include videos and other media. Again, recordings she might have done with other attorneys, clients, if she was taking verbal notes in a meeting. All of that has been in the hands of the state for over a year. The iCloud Drive, contacts, calendars, who did she meet, when did she meet them, bookmarks, maps, search history. Oh, I need to go meet somebody at for different reasons. I need a prospective client. I need to meet with that person. Now it's in the hand of the state. Messages, all of them. Device settings, backups, iCloud backups, Apple Watch backups. Question, what took so long for the warrant to be public? Because the prosecution and the investigators kept it a secret from the defense. The defense, by accident or by sheer luck, got notified about what happened because Apple or the iCloud or something, they got knowledge of it. And this was the Friday before that last hearing they had in December. They found out. Sounds unethical. In my opinion, highly unethical. And as Mexican Vader, remember people, you can never hate the government enough. Here's my opinion on the government. It's a necessary evil. Society is huge. We sadly need military because other countries are assholes. We need some kind of policing because people are sometimes bad. We need justice system, stuff like that. But governments will always try to overreach. Always. Once an entity gets power, they want to keep it and they want to extend it, especially governments. Let's continue. Voice memos. iMessage content, including but not limited to records of incoming and outgoing communications such as times, dates, sender phone number, everything. Associated devices such as other cell phones, iPads, and AirPods. So if she has family who are connected to her iCloud for some reason, or if she has one of these accounts that is shared, say they have her office have the same iCloud as the assistant or something like that, then everything is in. Find my iPhone data, including but not limited to, find my iPhone connection logs, location information, and find my iPhone transactional activity for requests to remotely lock or erase a device. Yeah, find my iPhone. If you have that on, it's constantly tracking you, by the way. Constantly. All records, data, and information, including but not limited to text messages, instant messages, voicemails, documents, images, photographs, all of that. Any backups for the above device uploaded to iCloud. FaceTime communication logs. iTunes account information, including but not limited to basic subscriber information. Everything about the iTunes. Recordings of account user with Siri. If Siri was listening in, now it's in the hand of the state and has been for over a year. Apple shall disclose this above responsive data, if any, by sending it to, those. Search to be conducted by law enforcement. Device registration information, including but not limited to customer, all of that. Apple ID and related accounts detail, including email addresses, account status, age, associated device information, serial number, and browse type. This provides proof of identity of the account holder, and presumably the user of said account at the time of the offense, and can be used to corroborate metadata in other files. Apple-based and third-party applications downloaded. This shall assist in identifying the identity of the account holder, and presumably the user of said account at the time of the offense. Searches within Apple apps. This shall assist in identifying the identity of the account holder and presumably the user of said account at the time of the offense. Furthermore, in my training and experience, it is common for users of cellular devices to download other applications for purposes of communication and or sharing photographs and videos. This will assist your affiant in determining which messaging platform was utilized to share the photograph. Searches will also include any images and references to Detective Danny Polo or his family. Detective Danny Polo was the witness who claimed he needed to testify in a ski mask. And it was revealed during his testimony that he had pictures public of him, which made the court say, well, if you have pictures public of yourself, that means you simply do not have that right to be testifying in a ski mask. That, folks, is what the prosecution and investigators are calling witness tampering, because Raven Liberty found out or got sent to her that image. She presented it to the court, and he had to reveal his face. That is what they are calling witness tampering. They presented, I don't know what, to a judge as witness tampering, but this, in my opinion, is revenge. Pure revenge for their mistake. That they had this guy on the stand in a ski mask claiming, oh, I'm under so much threat. Well, apparently not enough threat to have pictures of yourself with your family. Public. So this is what they claim. They needed everything in Raven Liberty's phone, contact information, recordings, mail. Who did she mail and when did she mail? What is in those emails? If it's on iCloud, who did she call? Who did she record? Everything has been in the hands of the cops and the state for over a fucking year. Just because Danny Polo was revealed to have public information and his photo was public, so he couldn't testify without a ski mask. That is what they're calling witness tampering. This is so insanely ridiculous. I mean, the overreach by these prosecutors it's, in my opinion, it's not bordering on misconduct. It's not bordering on unethical behavior. It is misconduct. It is unethical because for over a year, they have had access to attorney-client privileged information. Over a fucking year. And this is in a trial where the lead detective had to admit on the stand that he asked another police officer to lie for him. This is where the original prosecutor was thrown out by the court for her conduct. And then they do this. And then they do this. They get everything from before Raven Liberty was Mellys' attorney in February of 2019. They have everything she has done for the past 5 years, 6 years. For the past 6 years, everything she's ever done via an Apple device has been in the hands of the state for over a year. Jason said, correct me if I'm wrong, but that it was a Cash App profile that had his wife and himself and children in it. Yeah, it was something of the sort. Still public. Still made it the argument impossible for him to testify in the ski mask. And this is the revenge from the prosecution, from the state. And the reason, I believe, is simply that they are trying to ruin her. Who knows what information they have passed on regarding her other clients? I do not believe for a second, folks. I do not believe for a second that this Florida prosecution's office have not shared this information under the table, so to speak. Here is the information. Now try to find a workaround. So you can claim, oh, we found it another way. It's bonkers. Absolutely bonkers. Let's continue. Any searches for realtors as it relates to Detective Danny Polo. And it searches for Cash App as it relates to Danny Polo or his family. And it searches for Jacob Cherry, aka 1090 Jake. That is, if I understand it correct, that is the person who actually found this photo and related to the defense. And the reverse phone number searches for Detective Danny Polo or his family. Customer service records. This shall assist in identifying the identity of the account holder and presumably the user of said account at the time of the offense. Apple Media Services. Purchase, download transactions and connections. Update, re-download connections, IP address. It's everything that Raven Liberty has ever done with an iPhone. There are no limits. And FaceTime logs and everything. Photo stream data to include videos and other media as well as metadata, notably any images that would identify the primary user of the device or any images depicting Detective Danny Polo or his family members. They want to know if Raven Liberty followed or anything of the sort. I don't know. Any photographs of Detective Polo and or his family members. So if Raven Liberty asked one of her PIs, follow him, tell me what you found out, which is completely work product for the defense attorney. We need to find out stuff in order to try to discredit this witness. Completely normal attorney work, but now they know. iCloud photo library, iCloud Drive, contacts, calendars, bookmarks, Cash Apps applications, if it's user data. And then it searches within the application from Detective Polo or his family members. Messages from February 13th, 2019 to present related to witness tampering before she was hired by Mellys. Device settings, device backups, voice memos, notes related to Detective Danny Polo and his family members. This is attorney work product. This is related to her work with Mellys. This is attorney-client privileged information, in my opinion. And they specifically asked for it. That is why I believe that no matter what the prosecution says, they did this to find attorney-client privileged information, and they're using that the Danny Polo thing as an excuse. Because it's not witness tampering to find a photo to make the argument that he should not be allowed to testify in a ski mask. Find my data, including but not limited to, and all of that. Now, the first page is just lol. The last two pages is just this is science and everything. But seriously, folks, this is extremely serious. Extremely serious. Because it's attorney-client privileged information. They have, in my opinion, actively searched for, which is, it's at the level of disbarment, or should be at least, if they actively searches for this kind of things. Now, let's go to the next part of this. This is there. What does the prosecution try to... Now it's damage control. The prosecution wants to limit the information they found. They are asking the court, please, court, we fucked up. We did something unethical, but it will be harder for the defense to prove it if you just remove this extremely damaging information that we found. State's motion for protective order. Comes now the state of Florida by and through undersigned assistant state attorney and moves this honorable court to enter a protective order pursuant to this, and comments as follow. On December 27th, 2024, the defendant filed a motion for hearing to determine potential conflict. In this motion, it states the defendant's attorney, Raven Liberty, was informed on December 18th, 2024 by Apple. Yeah. So Apple notified Raven Liberty that they have handed over everything from or everything she's done for the past 6 years has been handed over to the state. Raven Liberty was informed on December 18th by Apple that on December 13th, 2023, that her Apple account information had been provided to the Broward Sheriff's Office pursuant to a search warrant. Monday, January 6th, I have that hearing. I covered it. This honorable court heard the defendant's motion. In addition, on January 6th, the states filed a motion for rehearing, reconsideration of defendant's alternate motion to compel disclosure of Apple's search warrant related to attorney Raven Liberty. On Tuesday, January 7th, 2025, this honorable court entered a written order ordering the state to provide a copy of the search warrant to the defendants to determine his potential conflict over the state's objection. Over the defendant's objection, this honorable court ruled it would review the search warrant in camera for potential redactions. Yeah, they wanted this in open court. But the judge says, I will do this in my chambers. Pursuant to this statute, the state hereby requests this honorable court enter a protective order restricting the disclosure of the search warrant, whether redacted or unredacted, to anyone outside the defense team or defendant due to the nature of the investigation and due to it still being a pending investigation at this time. Well, we just read the search warrant. Denying such a protective order would greatly impede the current investigation, allow suspects to avoid apprehension, and or allow for the destruction of evidence. I think you're more worried about the evidence of your misconduct, prosecutor and Broward County Sheriff's Office. That you're not scared of what Raven Liberty might do. Well, you are, kinda. But I think you're more scared of what will be the result of this. Hey, Cat Raid! Hey, Cat Raid! We have been reading Y&W Mellys, the search warrant. Yes, it is public. The search warrant is public. And the information in it is mind-blowing. The short version. The state accuses Raven Liberty, Y&W Mellys' attorney, for witness tampering. Witness tampering. Now, what was that witness tampering? If you watch that trial, the first trial against Y&W Mellys, a cop who started out testifying in a ski mask. And then mid-testimony, he had to remove the ski mask because the prosecution and he claimed he needs this protection. There are no images of him anywhere, and he's a former undercover, whatever's. And as it turns out, there was pictures of him online. The prosecution and Broward County Sheriff's Office, this is their revenge. they, in secret, of course, had applied for a search warrant of Raven Liberty's phone and iCloud data. All of it. For the past 6 years. Which includes, but is not limited to, all her client list. Her communications with her clients. If you go back and listen to it, what's not in that search warrant is not a limitation against attorney-client privilege information. There's no such thing in the entire search warrant. No such thing. So, which means that for the past year, the state and the sheriff's office have had everything Raven Liberty has done on her phone for the past 6 years. Recordings. Even if Theory listened in, those recordings are also in the hands of the state. Any searches, browsing history, everything for the past year, and everything. Because they found a picture of the witness, which forced him to remove the ski mask and testify with his face out. And they call it witness tampering by Raven Liberty, that she found, or somebody found and sent to her, the pictures, the public pictures of this Detective Polo. Hey! So, as I said earlier, is this unethical? Oh, hell yeah. Is this immoral? Oh, hell yeah. I would argue that this not only puts this entire trial, the YNW Mellys retrial, in jeopardy, it can possibly be talks about this with disbarment, because this is, we don't know the affidavits that were presented to a judge in order for him to write out an approval of this search warrant, because there's nothing in that search warrant that says that Raven Liberty was an attorney. Nothing. Hit the like button and everything you know you want to. So this is what we have been talking about the last 40 minutes. Go back, thumbs up, subscribe if you haven't. You know all that. And after all of that was revealed in the search warrant, now the prosecution wants to limit the defense access to what they found in that search warrant. Also known as, prosecution is more or less saying, we fucked up, Your Honor, but please limit the results of the search warrant, because that might prove the completeness. Because they have had 6 years of attorney-client privilege information in their hands for over a year, and they try to keep it a secret. Yeah, exactly, LTO. We actually don't know what they found yet. Let me continue reading from this. Denying such a protective order would greatly impede the current investigation, allow suspect to avoid apprehension, and/or allow for the destruction of evidence. It's Raven Liberty. You have everything in her, of any Apple device in her possession. You have it all. What is there to destroy? There are a litany of cases dealing with the courts requiring the states to produce information related to an ongoing investigation. Barfield v. City of Fort Lauderdale. The court held that under Florida law, quote unquote, active criminal investigation information is exempt from public disclosure until the investigation is concluded under FS paragraph 119. Yeah, but as the judge said in this trial, Melly is facing the death penalty. That supersedes any wants from the prosecution because they sought the death penalty. As discussed in Florida Pub Co. v. State, an executed search warrant and accompanying material is exempt from discovery and public records law pursuant to section blah blah blah. As such, the state requires such a protective order preventing the dissemination and or discussion of the Apple iCloud search warrant regarding Attorney Raven Liberty with anyone outside of the defendant's team of lawyers. Wherefore, the state hereby submits this motion for protective order preventing the dissemination and or discussion of the Apple iCloud search warrant regarding Attorney Raven Liberty. But, nope. Here it is, the search warrant, which we have been reading from the last 45 minutes. Allegedly, maybe. I'm not totally versed in what's going on, but isn't attorney-client privilege isn't affected by this search? In the search warrant, there are no limits. In the search warrant, there is nothing that excludes attorney-client privilege information. They have had this information for over a year, and not until the January hearing, there were talks about having the what do you call it? One of these groups that reads through the material and removes the attorney-client privileged information. Dark Lotus wasn't. Yeah, thank you, Dark Lotus. Taint team and panel. No, not until it was revealed in the hearing in December, and then not until after the judge ordered the state to produce this search warrant. Then they were asking for, let's get a taint team together. This is so improper. This is insanely. The misconduct here is off the walls. And for you who are new to the YNW Melly retrial, first trial, hung jury. Also in the first trial, the lead detective had to admit to the jury that he asked another police officer to lie for him. In the first trial, before the first trial, the lead prosecutor was thrown out because of misconduct. And now this. And now this. And all because this. Any images or references to Detective Danny Polo or his family. This is the revenge from the prosecution and the sheriff's office. This is what they are calling witness tampering, that Raven Liberty either found herself or got sent to her images of Detective Polo and his family, which was the reason Danny Polo testified behind the ski mask was, oh, his prior undercover, there are no pictures of him. There was, which made him take off his mask. That is what they're calling witness tampering. It's gobbledygook. It is absolutely insane. And again, I can't emphasize this enough. The prosecution and the sheriff's office have had access to attorney 6 years of attorney-client privilege information at the disposal for over a year. And in this, it's not limited to Y&W Mellys. All her contacts, all her emails, all her phone data, all her health data, all her geolocation. Where was she when she made a specific call? All recordings. If she recorded an interview with a client, or if she recorded with a witness, all those recordings have been in the hands of the state for over a year. Yeah, Mellys has been in county jail since March of 2019. He was 19 when he was sent off to jail. He's now 25. Yeah, as Leanne says, that affects all her other cases too. Yeah, if Mr. Mellys is not her only client, but now the state has all of her client list and every communications she's ever had, all communications the past 6 years with any of her clients have been in the hands of the state for over a year. Derek, hi. They found his picture, his wife's WhatsApp. Yeah. And that was enough for the court. Thank you, by the way. Thank you for your £2. Thank you. That is what the judge in the first trial said. Yeah, you can't have a ski mask anymore. Allegedly, maybe. My jaw is dropped to the floor. I get Y&W Mellys isn't a good guy, but that's uncalled for a search warrant. It's the next step here, in my opinion, is the result. Well, we know it's damaging. We know they have had everything she's ever communicated via her Apple devices is now in the hands of the state. What is interesting is the affidavits. What did they claim to a judge to get this garbage approved? No, he didn't lie to the court about being a former undercover agent. But the reason, because being an active undercover agent, off limits. A prior undercover agent, if he left that part of his job for a number of years, then that is no longer, according to that court, doesn't matter anymore. So it wasn't enough, because if the prosecution hadn't been so unethical, if they didn't go to such extremes to get evidence, the case is strong, folks. Yes, it has holes in it, which the defense in the first trial successfully, ta-da! But if that cop hadn't asked another cop to lie for him, if they just waited and got everything in order, that would have gone away. If the first prosecutor hadn't tried to, whatever she did, to get herself thrown off, that wouldn't have been an issue either. But it seems like Florida is a cesspool of government or prosecutorial misconduct. Leanne, do you think they will ever get the affidavit? with this, they will certainly ask for it. Will they get it? I would approve of it, but I'm not a Florida judge. Lucky for Florida. But this is insanity. Doc Lopez says here, her whole book of business was burned by the state. Ethically, wouldn't Raven have to conflict out of all the casework she was engaged in? Well, every other case she's involved in, she probably is going to seek a dismissal on these grounds that Florida or this particular, I mean, whatever case she has, in whatever jurisdiction she has, she cannot argue the state have had attorney-client privilege information at their hands for over a year. Now, I'm sure the Broward cops will say in an affidavit, oh, we never looked at it. But that's not the point, folks. You gave yourself access through this absolutely garbage search warrant. So yes, I hope that the affidavits will shortly be in the hands of the defense. I assume they will ask for it again. And I hope the judge will approve of it. Because this new judge, because the prior judge retired, so this is a completely new judge who gave the order for them to, you need to hand it over. And then they tried to make a reconsider, and he just said, hand it the fuck over. Well, not by those words, but still. It's so yeah. Now the one reason I follow this case is because Jeff, legal vices. There's a bunch of us that has been taking over his cases, so this is mine, so to speak. In my chat, you will see a bunch of Jeff's moderators. I think I have modded most of them who have asked for it. So yeah, I will cover the YNW Mellys trial. I will actually be in Miami in September when the YNW Mellys trial is ongoing, and I will try to get into that courtroom to watch this firsthand. I will have as help the same person who helped Jeff. Jules will be when she can be in court, she will be my eyes and ears in court. So September, folks, this trial will start in September. There will be a lot more hearings before that. I will cover them all. Same as the YSL trial, gavel to gavel. In September, my first stop in September is to Utah, because I'm visiting Jeff's family and his grave. And then I will move down, then I will fly down to Miami, spend a week there before I fly home again. So this is the YNW Mellys case. Other than that, well, you know, I cover the A. Separelli trial. You know, I will cover the YSL trial part 2. That is now moved to June. And I also cover the California celebrity hairdresser murder trial, where we found out last week that both the victim and the supposed killer were both cheating whores. Yes, I sometimes use very colorful language. So those are the cases on my docket at the moment. I hope you can stick with me for those. But this was the search warrant. This was the desperate attempt from the Broward County and the prosecutor to at least limit the amount of information that is handed out. I don't think it will help them. I hope it won't help them. There will be a new hearing coming soon in the YNW Mellys trial, and I will cover it. Be damn sure, because that is a faster clock as well. Most of my trials are. But until then, thank you. Go back, listen to all of it. Hit thumbs up, subscribe if you haven't. And from me and Mr. Jingle, thank you for allowing me to do this. Without you, this channel is nothing. Thank you. Until tomorrow. Yeah, tomorrow. Probably the hairdresser trial. Trying to catch up a bit with that. And then Thursday, we will probably listen to some closing arguments. But everybody, thank you so much for being here. And remember, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. I will send you off with my new ASAP Rally outro. It's a song I made on suno.com. Have a good one. See you tomorrow. Bye-bye.
Rocky's sitting there ain't smiling. Lewin's voice high-pitched trialing. They say he shot taking a chance, but evidence ain't got a glance. Witnesses mumbling scared straight. Nothing clear in this debate. Pointing fingers without a clue. Lewin's case falling through. Where the proof they keep on hollering echoes through the room, just following empty claims circling the fight. Truth hidden out of sight. Courtroom buzzing in confusion. Accusations feel like an illusion. Rocky silent eyes like fire. Holding out of sight. Courtroom buzzing in confusion. Accusations feel like an illusion. Rocky silent eyes like fire. Holding ground through this mire. Evidence, so where you hiding? Justice on thin ice just sliding. Prosecutor's voice keeps breaking, but the truth remains unshaken. Doc's reports ain't showing much. No fingerprints, no guilty touch. Suspicion's high and runs wild, but innocence stands beguiled.